Welcome to the second in our three-part series on what to do when a loved one dies. The development of this series grew out of our experience in counseling clients for over 30 years. We've observed people who had not quite gotten through the grieving process over the loss of a loved one quickly being required to step out of their comfort zones to handle the business and legal affairs of a friend or family member who had recently passed. The first presentation in our three-part series will provide you the information which you will need to know in the days and weeks after someone's death. And the third part in this series discusses the probate court process, which must be used if someone dies just having a will or having done no planning at all. This presentation is meant to provide a basic understanding of the trust administration process. It is provided for educational purposes and is not intended to create an attorney-client relationship between the viewer and the Hayes Law Firm. We always recommend that you seek the services of an experienced professional to provide the guidance needed with regard to the specific aspects of trust administration. Our major motivation for creating this webinar series is to let you know that you are not alone in trying to navigate these unfamiliar matters and to also provide you direction as to the next steps that you need to take so that you can properly and competently handle these matters in a way that brings honor to your deceased friend or family member. As the trustee of a trust, you have chosen to conclude the affairs of someone's life on earth. We want to support you in properly handling the legacy of a life that had meaning for you and others. It is important that you understand that this presentation will be a summary of the trust administration process. It is provided as a general guide of the procedures needed for effective trust administration, which will apply if the creator of the trust should become incapacitated or die. Every situation will differ, and of course, there may be changes in the law which impact the way in which the trust is administered. It is always advised that you seek the services of a professional. Today's presentation will take you through the administrative steps necessary to gain control of the trust assets, handle its creditors, pay any outstanding taxes, provide an accounting to the beneficiaries, and finally, to distribute the trust assets to the appropriate person and institutions. In this presentation, we will cover the most important things you will need to do in the coming days, weeks, and months ahead to ensure there are no surprises or costly mistakes. Whether your loved one had a trust or no estate plan at all, we have a webinar for you. At the end of this webinar, you will receive an email with instructions on how to register for the appropriate webinar based on your circumstances. Now, why should you listen to me talk about these important matters in your life? Well, I've not only got all the training to understand the legal and tax issues, but I've got a real passion for this work. My name is William Hayes, and I've been a licensed attorney for over 30 years. On the screen, you can see a summary of my educational and legal background. Our firm has been located in the historic Behringer Studios building for over 22 years. As an estate planning firm, we have served as a source for estate planning information for many of the major media outlets. And I am proud to say that we consistently earn 5-star ratings on most of the major social media. Anyone involved in the administration of a trust should take the time to thoroughly review the language of the trust. It may be that you do not understand all of the terminology, and some of the terminology may be irrelevant to the administration that you are performing. However, if you do not clearly understand its terms, it is important that you consult with someone who does understand the meaning of the trust terms. You do not want to have yourself in a position where you have misinterpreted the language and could expose you or the trust to liability in any way. After having read the trust and developing an understanding of its basic terminology, you want to make sure that you understand the authority which has been granted to you as a successor trustee. Each trust has language discussing the authority of the successor trustee. Most trusts will provide broad discretion for the successor regarding the trust administration. However, it is not uncommon that there are limits placed on the successor trustee, which of course will impact the degree of the authority of the trustee. There are certain documents which will have to be filed upon the death of the original trustee. If the original trustee owned real estate, you will want to file an affidavit of death for this trustee. with the county recorder. We recommend that any new successor trustee also create a document evidencing the acceptance of the position of successor trustee. You will want to have this document to provide during your interactions with financial institutions and others who may raise this as an issue regarding your authority. A primary obligation of the successor trustee is to prepare an inventory of all assets owned by the original trustee. That does not mean that you must count every knife or fork in the kitchen drawer. It does, however, mean that you will want to account for assets such as real estate, financial accounts, and other assets of significant value. Having a death certificate in your possession is essential to any trust administration. We often recommend that you order at least 10 copies because you will often have to provide these certificates when handling transactions with financial institutions and with regard to any real estate assets. Within 60 days of accepting the position of successor trustee, you should notify the beneficiaries of the trust in the manner required by law. The appropriate language of the notice is governed by the California Probate Code. You will also have to determine what debts the trustee had remaining. Did the trust creator die while owing financial and tax obligations? Much of the work of the trustee will involve going through the paperwork of the deceased trustee and determining what must be done with the various assets. So you will want to find out whether the deceased had any health insurance, credit cards, debts, pensions, memberships, or subscriptions. It may also be necessary for you to contact credit reporting agencies so that you can advise them of the trustee's death. A report should also be made to the Social Security Administration. However, the organization which handled the funeral, burial, or cremation of the deceased trustee will usually advise the Social Security Administration of this death. With regard to real estate, there are many steps that need to be considered. For instance, you may want to look at retitling the deeds on the real estate so that it will be placed in the names of the beneficiaries, and you will want to file any affidavits which you are legally required to file. Once you have the death certificate in hand, you will want to gain control of the financial accounts of the deceased trustee. To the degree that it is possible, you will want to consolidate all of the accounts into one account titled in your name in the capacity as your being the trustee of the deceased person's trust. If the deceased trustee had any unpaid taxes, it will be your obligation as successor trustee to have those final tax returns prepared. It is always wise to seek the services of a professional in this regard, so I would advise that you retain the services of a certified public accountant. If there will be any income coming into the trust during your administration as successor trustee, it will be necessary that you file tax returns to reflect that income. As the successor trustee, you are obligated to gather, evaluate, sell, and/or keep assets, pay the debts and taxes of the deceased trustee, and finally to distribute the balance of the trust assets in accordance with the terms of the trust. Where required, you may have to prepare a written accounting for submission to the beneficiaries of the trust. The language of most trusts require that the successor trustee be paid reasonable compensation for their services. Depending on your occupation and experience, reasonable compensation can be interpreted to mean that you can be paid either an hourly rate or a percentage of the total trust assets. As the successor trustee, you are entitled to hire an attorney, and that attorney will usually handle most of the significant trust administration tasks. This will have no impact on your compensation as the successor trustee. All costs and fees are paid from the assets of the trust. There are many reasons why a successor trustee may wish to consider hiring an attorney to provide guidance with regard to the trust administration. An experienced attorney has been through this process many times before. If you have experience on your side, you will not have to be concerned about whether you are making the right moves as you conduct the administration of the trust. Secondly, A, a reason for hiring the attorney is that most of the trust administration work will be handled by the attorney. When there is an attorney involved, the successor trustee's primary function will be to provide information to the attorney, and the rest of the work can be handled by the attorney. Number three, another reason to hire an attorney is because the attorney will likely be well versed in the regulations, rules, and requirements of the trust administration process. An experienced attorney will know the laws and policies that govern trust administration. Four, hiring an attorney will help you to minimize the potential for complaints and lawsuits and avoid destructive family disputes. And lastly, in most cases, you will not be personally liable for the attorney's fees, since all expenses are paid from the trust. If you are going to administer a trust, it will always be of benefit to you to at least consult with experienced professionals. The professionals usually returning during a trust administration are an accountant, a financial advisor, and an attorney. These are professionals who have been down that road before and will make sure that you are able to navigate this administration safely and competently, because what you don't know really can hurt you. If you have been designated the successor trustee to replace a disabled or deceased trustee, you would be wise to begin your administrative tasks without delay, so that you can be sure that you've done all that is expected of you in a timely fashion. As the successor trustee of someone's trust, our office will provide you a free consultation so that you will have a clear direction as to what you need to do next. Thank you for listening to our presentation. And if we can be of assistance to you in your capacity as a successor trustee, please call our office today. Additionally, if you need any assistance regarding the planning of your own estate, the handling of the probate for someone else who has died, or if you or someone that you know has a problem with long-term care health expenses and they want to use Medicaid while protecting their assets, please reach out to us today, and we will be sure to provide you all of the assistance that we can. Thank you very much.